Greenpeace Europe, and we are mostly supporting the movement and trying to help also Greenpeace with collaborative campaigns to enhance the work that we do. And one of them is the anti-repression work, because as we are seeing everywhere, the repression against climate or human rights activists is worsening, it's more strict. And that's why we are trying to support the movements in this way as well. We are coordinating a network called Legally Green. It's a network of lawyers and legal activist support groups from all around Europe, and that is supporting each other, exchanging on strategies and developments. Even in the Czech Republic, where I'm from, this week had seen 2 big court case decisions. One was about the climate litigation for Czech Republic, which was denied by the highest court. And then some coal activists lost a case against a coal company for who was suing them for lost revenue. So when so many things are happening in such a small country as the Czech Republic, you can imagine how it looks like on a big scale. I'm super happy that 3 amazing people had accepted the invitation for this webinar. We have Daniel from Greenpeace International, we have Nancy from CASP, Climate Action Support Pathway, and Joël from Terre de Lutte from France. They will all share about their work and what do they do. And there is an option to ask questions on the bottom panel in your Zoom. You should see a Q&A, and you can ask directly there. It is more easy for us to keep track. And the inputs of our panelists will be recorded. So I think we will start it soon. Yes, feel free to use the webinar chat. It's the only way to interact in this Zoom webinar function. So please feel free to engage there. However, please be polite. We won't tolerate any hate speech. Yes, so I'm not going to take space any longer, and I'm going to give words to our first panelist, who's Daniel. Here we go.
Thanks, Bashka, and good evening, everyone. So my name is Daniel Simons. I'm a senior legal counsel at Greenpeace International. I've been at Greenpeace International for 16 years, trying to deal with all the incoming court cases. And Bashka asked me to summarize what I've learned in 10 minutes, speaking slowly for the interpreters. So wish me luck. I'm going to bring up my PowerPoint, and I'll start also, while I'm doing that, with a little disclaimer that, of course, this is my experience from Greenpeace International, and I know that some of you will be from smaller organizations, so not everything I say here is maybe within reach for a more grassroots type of organization, but hopefully there will be some inspiration for everybody. So, what do I want to talk about? Firstly, what I've learned over the years is building a good defense and a good campaign around the court case that starts before you actually do a protest. So there are already things you can do, and I want to talk a bit about that. Secondly, what can you do inside the trial? There are various legal strategies and tactics that you can use to advance a campaign. And then thirdly, surrounding the trial, what kind of outside trial strategies are there? So if we dive into the theory of this, the opponent's script is almost always something like this. They will say, when I say the opponent, by the way, I mean, the prosecution, or if it's a civil dispute, the party that is suing you, they will always say something like this, like, we respect the right to protest, but in this case, it was unsafe, or it was obstructive, or it was unlawful, or it's a stunt, it's anti-democratic, it's not the way to have a conversation about a serious topic, and so on. And here you see, a screenshot from the Shell website where they are saying exactly this about an ongoing dispute with Greenpeace. So what are the things that you can do even before the protest starts to get away from the script. Yeah, we want to make sure that we can, talk about the real issues and not get stuck in debating the script. So the first thing I would say is it's good to be able to document that mature conversation that, say, has failed. So you have tried to, have a dialogue about the issue that's concerning you, but you've reached the end of the road, and therefore it is appropriate to resort to protest tactics. That's the first thing. And I think any judge is going to have that question in their mind. Why was it necessary to do this aggressive protest? So it's good to have a clearly documented answer to that. Secondly, good to have a very clearly documented safety protocol, so you can immediately show, like, the allegations that this was reckless are not true. These are all the steps that were taken. The third thing that I've learned at some point is that it's actually a good idea to send a letter at the start of a protest to the targets of the protest, and to sort of explain, what are we doing, how are we doing it, why are we doing it, how can you reach us if you have safety concerns? Because then, if they don't reach out to you, they already have some explaining to do. Why was their concern genuine? Definitely a good idea to document the protest so you can demonstrate that the safety allegations are not correct. Nowadays, Greenpeace activists often have on their helmet, they have a GoPro camera. And in many court cases, I found that this GoPro footage is very essential in refuting allegations of unsafe conduct. And then this is a more controversial point, I think, about info security. A lot of us love to do everything on Signal and with deleting messages, and to have code names for activities and so on. I mean, I think that's useful if you want to make sure that the activity is not discovered beforehand and you can actually go ahead. But in terms of the optics in a trial, it can be harmful. If you're saying, we are doing something that's normal in a democracy, we're honest citizens and so on, the prosecutor might say, well, why are you using code names and operating like a criminal gang with burner telephones and, high-level encryption and things like that. So that's something to think a bit about. Also, I mean, this is also debate in the movement, I think, about showing your identity and so on. I know that's a luxury not everyone can afford, but I would say I always love it if defendants in a case actually are, have been completely public about who they are throughout, for the same reason, that it shows that, I'm an honest citizen. I don't have anything to hide. I'm doing this from my conscience. So therefore, I'm sharing my name, publicly in the trial and so on. And the last point is, I think it can be good sometimes to be humorous around activities, because it's kind of hard to attack someone who's funny. Often, the public is on the side of the funny person. Also, make a protest beautiful. I remember a very high-risk protest that Greenpeace undertook, where I said, it was not a very serious comment, but I sort of said, make sure this protest is beautiful so people will like it, And they did such a great job on it. It was a protest with activists hanging from a bridge, and had beautiful, colorful banners with them hanging down from the bridge. And it was like a really inspiring image that somehow I think helped with a judge and so on to see, like, this was not some kind of awful militant event. This was almost like an art installation. It had a very different visual impact, the protest, as a result. I'm going to skip what you see here, the screenshot, and I'm going to go to my next slide. In-trial strategies. So we don't want to really debate about what we did and whether it was unsafe or not, but we want to talk about why we did it. And for that, it really helps, in my experience, to be very forthcoming with the facts. If you're working with a criminal defense lawyer, usually their clients will be people who are criminals, maybe, or at least, seriously suspected of being criminals. And their instinct is usually to say, to challenge the facts that the prosecutor is advancing and say, this is not proven correctly and so on. But then you could spend a lot of time talking about that, about what actually happened. Sometimes it's necessary. If you're falsely accused of things that didn't happen, you need to refute that. But otherwise, it can be a good idea to just say, here's what we did exactly. Here are the facts on a piece of paper. We don't need to talk about that. Everything's admitted. We only need to talk about the reasons why. And legally speaking, there are sort of two strategies to shift the discussion to the why. The first strategy, and there might be more, but these are the two general ones that you find in most sort of activist defense cases. Firstly, invoke the right to protest, Articles 10 and 11 of the European Convention on Human Rights. That means the opposing side has the burden to prove that the measure they're proposing, the penalty or the compensation that they want you to pay, that measure is necessary in a democratic society. That's a requirement under the European Convention. So that opens up the possibility for you to talk about the importance of nonviolent direct action or civil disobedience or protest in a democracy, and the importance of the topic of the protests. Sometimes judges will say, I accept all of that. I know climate change is important, for example. You don't need to prove that. But sometimes the freedom of expression argument allows you to talk about, well, for example, this new coal mine is going to cause so many deaths, it's going to cause so many emissions, and so on. You can go into detail. Also, the second theory is then to invoke an argument like state of necessity, self-defense, lawful excuse. There are different terms in different countries, but the idea here is that you are committing a minor wrong in order to avert a much bigger wrong. And that is something that is allowed generally under criminal law. The problem is you do bear the burden of proof yourself to prove that. But it offers a good opportunity to talk about the scale of the harm that you're trying to avoid. So to demonstrate that that's really a serious issue. I'm going to be very quick with this. Couple of illustrations. A case in the Netherlands where Greenpeace activists went into the 500-meter safety zone around a gas drilling platform. They clearly broke the mining law in the Netherlands, which says you can't do that. But the courts acquitted them based on freedom of expression, saying that, the protest was actually not unsafe. They were able to prove that, and therefore convicting the activists is not necessary in a democratic society. So that's the first two of the two approaches, the freedom of expression one. And then another case, Kingsnorth 6 case, where activists climbed on a coal-fired power plant and painted a message on the chimney. And they said, they had witnesses who backed them up that they were trying to avert a serious wrong, namely that area could even flood as a result of climate change. And the jury accepted that they were acting out of an immediate need to protect property of other people, and they were acquitted. So that's the second theory. Some more tactics you can use in trial: bringing in expert witnesses. In the Kingsnorth case on my previous slide, there was, for example, a leading climate scientist came to talk about the harm that this coal-fired power plant was doing. Another one talked about the flooding that would result in the area where the jury was from as a result of climate change in an unmitigated scenario. There was also a witness who came from Greenland to talk about the very real impacts that the Inuit are experiencing there. So yeah, those are some examples of the types of witnesses you can bring. Sometimes you can bring in hostile witnesses. So these are people who are actually not on your side, but who you want to question because you think they have some interesting information and you'd like them to declare under oath. An example I can give here is a case in Japan where Greenpeace Japan, with the help of a whistleblower from the whaling industry, found out there was a big scandal where the staff of the whaling vessels were actually stealing the best meat and selling it for their own gain. So we actually brought some of those people, those individuals who are stealing the meat, into courts and questioned them in court. And we kind of exposed their lies because they were clearly contradicting themselves. So yeah, that's also an interesting tactic. And then in some types of trials, you have the right to disclosure. Criminal trials, exculpatory evidence, so evidence that the prosecutor has that could help you. In this Japanese case, actually the police had first investigated the scandal, and then they had decided to prosecute the Greenpeace staff members who exposed the scandal, saying that they had gone into a warehouse where they shouldn't be to gather the evidence. But we used the trial to get at the information that the police had gathered when they were still investigating the real crime. So we got at that through the trial, and that was very interesting. You also have something called civil disclosure in some countries, where you can force the other side who's suing you to disclose their internal documents that are relevant. And then the last slide, I think, tactics outside the courtroom. It's always a great idea. The first one is obvious: to seek third-party endorsers, to have, academics write in the newspaper backing the importance of your case, celebrities, if you can get them to say that you should be acquitted or case should be thrown out or whatever, that can help a lot. Involving international mechanisms. There is, for example, the Special Rapporteur on Environmental Defenders of the United Nations under the Aarhus Convention, Michel Forst. You can complain to him if your rights are being violated. There are other United Nations mechanisms: Special Rapporteur on Freedom of Expression, Special Rapporteur on Freedom of Assembly, and so on. And they will sometimes speak out in your favor. Sometimes you can bolster your case by making a Freedom of Information request or a data subject access request. This is something under, the GDPR, the General Data Protection Regulation, gives you the right to ask for information about yourself. For example, in a case I'm working on now where Shell is suing Greenpeace International, we're going to ask them for disclosure of the information they have about some of our employees, because we think that they might have been, gathering data on them, and they probably don't want to disclose this. So, that's something you kind of counter-strike that's possible. Freedom of information requests. You see an example from the Japanese case. We requested access to statistics about whale meat production in order to show that there was a shortfall from all the meat that was being stolen. And we get this, blacked out document. That was obviously a great talking point for the media to show the lack of transparency around whale meat production. Humor, again, it's an underappreciated thing, I think. If you introduce humor around your case, like here, this Just Call Saul parody that we're doing, you can find on Greenpeace UK's social media profiles, where we're parodying Shell. That kind of thing is engaging for the public and can get them to be curious about what your case is about. It's not always so overly serious. Last point, fundraising. Obvious why you would want to do that. But I also think it's a sort of mitigation. If someone's suing you and they see that you're growing rich because you're being sued or because you're being prosecuted, obviously that makes the case less attractive for them. So it has two benefits, bringing in new funds for your defense and also making the case against you less attractive. That's it. Thanks. I hope I respected the time. I'm afraid maybe not, but...
You did, and you also spoke relatively slowly. So thank you so much, and thank you for your presentation. If people have any additional questions, please do write them, and we will get to them after all the three inputs. And I'm going to pass the word to Nancy, and I will also share your slides.
Thank you very much, Vashka. It's lovely to be here. I feel like Vashka set me a tough task to cover this topic in 10 minutes, but I'm going to talk about legal defences that are available to people taking action in England and Wales, and how the government has tried to kind of attack this over the past few years, with a focus on people taking action for the climate. And to get there, we have to do a little bit of climbing to talk about what the defences are before we can look at how the government attacked them. Bashka, we see you, not me. Never mind, that'll be nice for everyone. That's lovely. Okay, so this slide is just a bit of background really to show how the landscape has changed since the current climate movements got going in 2018. So at that time, there was a presumption that peaceful protesters wouldn't get prison sentences in England, and unfortunately that's not the case any longer. Extinction Rebellion started in October 2018, and although many people took direct action and were arrested, we didn't see anyone given a prison sentence until 2021, when James Brown was given a 12-month sentence for gluing himself on top of a plane at London City Airport. This was a very shocking moment, an Extinction Rebellion in the UK, but we didn't immediately see a lot more custodial sentences. So then in 2022, the government brought in some new protest laws. And one of the things they did was codify the offence of public nuisance, which was previously a common law offence. And the new codified version of the offence has a maximum sentence of 10 years. Now, following that change, we've seen much higher sentences for peaceful protesters. Just to pick out the very highest sentences that have been given, in 2023, Morgan Troland and Marcus Decker were sentenced for their action obstructing one of the bridges over the Thames. And they received what were, at the time, record prison sentences of 3 years and 2 years, 7 months, respectively. Then earlier this year, we had a group of 5 people who were named the Whole Truth 5, who were convicted of conspiracy to commit public nuisance for things that they said in a Zoom call for people considering taking part in a Just Stop Oil campaign. And they got sentences of 5 and 4 years. So they currently hold the record for sentences for climate activists in England and Wales. And really, this is just to show how quickly the stakes for activists have got much higher. And we've seen quite a large number of people given prison sentences, not just these people on the slide. If we move on to the next slide, please, Bashka. To understand how the government and the judiciary have tried to chip away climate defences, this is just some of the most common defences that people might want to argue in a protest trial. So Daniel already mentioned necessity and human rights, which are general defences that would apply to many, if not all, offences. There were also some statutory defences to specific offences, so that are like written in to the law. So reasonable excuse is a statutory defence to quite a lot of common protest offences, and that's how in practice human rights arguments would be brought in. So the reasonable excuse, people would say the reasonable excuse for their behaviour is that they were exercising their rights to freedom of expression or freedom of assembly. Criminal damage has got 2 particular statutory defences: protection of property and belief in consent, which we'll talk about later on. So slide number 4. Imagine you're on trial and you want to argue that you have a legal defence for your actions. This is the process that you would use for trials in the upper court. The defendant or their lawyer will write a short statement before the trial to tell the court and prosecution which defences they plan to rely on. But then the judge will decide whether the defences can be argued in front of the jury. The judge can either do this at the start of the trial, or if they're feeling kind, they can allow the defendants to introduce the evidence for a defence before they make their ruling on it. And there are specific case law that applies to different defences that the judge has to take into account when they make that decision. I want to connect here really quickly to Daniel's talk. So if defences like human rights or necessity are ruled out, people can be prevented from giving evidence about them. It can actually prevent people bringing in the why of their action into court, which is obviously very difficult for people, because protest only makes sense in the context of why you did it. Otherwise, it's inexplicable to do these things. Necessity is not really allowed in practice in climate cases in the UK generally, because the case law states that protesters in a functioning democracy should campaign through conventional means. We could debate whether the UK is a functioning democracy, but it's important to note that necessity could well be allowed in animal rights movement trials like animal rescues, and has also been allowed in some Palestine actions like arms factory property damage. So if we move on, we climbed the hill and now we finally get to the top. We can start looking at defences being chipped away. This is a photo of the Colston Four. They're a group of anti-racist activists who were at a Black Lives Matter protest in Bristol. They pulled down a statue of Edward Colston, who was a transatlantic slave trader. The statue was pulled through the street and dumped in the harbour. At their criminal damage trial, they made human rights arguments and were acquitted by the jury. So the jury said they were not guilty. While we never know why a jury reaches their verdict, the inference is that the jury probably felt this was a valid exercise of their right to freedom of expression. Let's look at the next slide. So the government was not happy that they were acquitted, and the Attorney General, the head legal advisor to the government, went to the Court of Appeal to ask them to make a ruling on whether relying on convention rights could be a valid defence in protest property damage cases. The Court of Appeal judges held that if property damage is significant, then defendants are not protected by the Human Rights Convention. The reasoning is that property damage is not peaceful protest, so it's not protected. And it doesn't matter how the damage was actually carried out, even if it was done in a careful and peaceful manner without risking harm to anyone. So judges' hands are now tied on this one. If the damage caused was significant, then the defence can't be put to the jury. That said, we have seen this defence ruled out in one case where the value of the damage was estimated at £160, which is not a lot more than €160, which I don't think seems very significant. This change works retrospectively, so it applied to people who had carried out their actions before the Court of Appeal decision. If we look at the next slide, this is a picture of an Extinction Rebellion activist very carefully cracking a window at the HSBC headquarters in London. HSBC and Burning Pink activists had criminal damage trials which took place after the Court of Appeal had ruled on the Attorney General reference in the Colston case. So these groups couldn't make human rights arguments in front of their juries. These defendants relied on the belief in consent defence, which is that the person honestly believed at the time of their action that if the owner of the property had understood the damage and its circumstance, then they would have agreed to it. This belief need not just be justified, but it must be the person's honestly held opinion at the time that they carry out their action. These defendants were also found not guilty by their juries. So you can imagine the government was again very unhappy. The Attorney General made another reference to the Court of Appeal. So let's look at the next slide, thank you. We just saw that the defence of belief in consent refers to the damage and its circumstances. So the question that was posed to the Court of Appeal was, what can be included in the circumstances of damage, and can it include the issue a protester wants to draw attention to, such as climate breakdown? The Court of Appeal said the circumstances of the damage do not include the merits, urgency, or importance of the matter about which the defendant is protesting. However, the fact that the damage was caused as part of a protest is a circumstance of the damage. So this defence has been restricted, but it hasn't been completely removed, and it's not clear yet exactly how this will play out. We know that at least one judge in a protest case has allowed the defence to go to the jury since the Court of Appeal's decisions. So it seems that judges' hands are not completely tied on this one, and they still have a little bit of leeway about whether to allow this defence to go to the jury. Shall we move on? There we go. So earlier this year, the Conservative government published draft legislation called the Criminal Justice Bill, which contained several attacks on the right to protest. People are often found not guilty of offences like obstructing the highway, possibly as high as 40% of defendants, on human rights grounds. So basically that criminalising their protest would be a disproportionate interference with their Article 10 and or Article 11 rights. And the government wanted to put a stop to this. One of their proposals was to amend lots of common protest offences to say that the reasonable excuse defence does not apply to people who are protesting. And this change would have meant that the ability to make human rights arguments in court might have been removed from any common protest tactics. I say might because even if that defence was removed, we would still have Article 10 and Article 11 rights. So I don't think we really know how it would have worked, but luckily it did not become law due to the election this summer. So this defence still applies to protest cases for the relevant offences. So the changes that I've talked about earlier only applied to property damage, which is a fairly commonly used tactic in the UK, but didn't apply to other forms of protest. If this change had come into effect, it would have applied to other tactics, including very mild protest tactics like walking in the road or sitting in the road. Since July, we've had a new Labour government, and it is yet to be seen what they might do in relation to protest law. One indication, which is not very encouraging, is that they are repealing a court ruling against the previous government. So Liberty, a civil liberties group, took the previous government to court. The court ruled against the government. And then we had the election. The new government could quite easily have done nothing and left it, but they are repealing. So that's not such an encouraging start. So what can defendants do now? People in the UK, oh, slow march trial. Okay, sorry, go on. It was a new offence was brought in of interference with key national infrastructure, which includes all A and B roads and motorways, so everything but minor roads in the UK. So this meant that you could now get a jury trial for walking in the road. The offence has got a statutory defence of reasonable excuse, but it was ruled out by the judge. So the defendants weren't allowed to make those human rights arguments. They were found guilty, and one of them got a custodial sentence for walking in the road, which is a first in the UK. And that's Phoebe, who also appears on my first title slide and who is in prison right now. So let's move on to the next page. What can defendants do? We still have a right to protest and we still have some defences. The government didn't succeed in removing the reasonable excuse defence. The worst affected defence is criminal damage, but even so, we still see some acquittals and some deadlocked juries. And just as an example, a Just Stop Oil group who caused damage to petrol pumps at a service station were recently acquitted by the jury, even though the judge ruled that they didn't have a legal defence. Defendants who don't have any legal defences can appeal to legitimacy over legality and focus on telling the jury about who they are and why they took action. They can also make arguments about jury equity, a doctrine in English law stating that jurors always have the right to reach a verdict in accordance with their conscience. And finally, that brings me to my last slide, which is about the Defend Our Juries campaign, which started with a campaign on jury equity. People would gather outside courts where protest trials were taking place, silently holding placards which stated jurors' absolute right to acquit defendants even where they have no legal defence. Some people were arrested for holding those placards. Some people were threatened with prosecution for perverting the course of justice or contempt of court, including one person in particular, Trudy Warner, who was persecuted by the government and who faced prosecution and potentially up to 2 years imprisonment. However, the charges were eventually dropped against her. And Defend Our Juries is now running a civil disobedience campaign asking the Attorney General to release the political prisoners who are currently imprisoned in the UK, which I believe as of today is 40 people from the climate and Palestine movements. So that's everything that I wanted to say. Thank you all so much.
Thank you, Nancy. I hope the video was fixed and people saw you and not me. And thank you for letting us try and get a grasp of all these crazy developments in the UK. I think we can get back to that in the questions time. And now I would pass the word to Joël.
Oui, bonsoir. Déjà, je laisse une petite minute pour vérifier que la traduction fonctionne bien. C'est bon? Ok. Oui, du coup, moi aussi, je fais face un peu à un défi en 10-15 minutes qui est celui de parler à la fois de la répression et tout en essayant de ne pas parler du contexte dans lequel on l'a subi. Parce que c'est toujours un peu le problème de parler de la répression, c'est qu'on parle moins de la lutte finalement pour laquelle on est réprimé que de parler de la répression. Et ça, c'est toujours un peu difficile pour les militants venant du terrain. Mais je vais quand même faire un petit point de contexte pour dire un tout petit peu d'où je viens. Donc, je viens de Bure, dans l'est de la France, un territoire très rural où il y a une lutte depuis 30 ans anti-nucléaire. Où il y a un des plus gros projets d'aménagement d'Europe qui vise à enfouir les déchets les plus radioactifs de France à 500 mètres sous terre. Voilà pour le contexte. Et il y a une occupation qui, depuis quelques années, une occupation, une mobilisation qui, sur place, grandit depuis plusieurs années et est devenue très intense autour de 2016 et qui a fait venir des milliers de personnes dans ces années-là à Bure. Ce qui a provoqué évidemment ce qui va en face, c'est-à-dire une répression accrue, une présence policière, puis une judiciarisation importante. Donc là, je vais peut-être venir plutôt sur l'objet qui nous intéresse. C'est déjà, je voulais commencer à découper en 3 phases, ce qui pour moi a été la progression du contexte. Donc on a une phase de surveillance, une phase de militarisation et une phase de judiciarisation. La phase de surveillance qui s'est étendue sur 2 ans, c'était d'abord comprendre comment on fonctionne, savoir qui sont les militants mobilisés, avoir une compréhension du contexte. Donc, on a une surveillance discrète avec des agents en voiture banalisée qui prennent des photos de loin, qui essaient de comprendre qui on est. Ensuite, on a une militarisation. Une fois que le renseignement policier a mieux compris qui on était, on a la mise en place de contrôles systématiques, un quadrillage du territoire. Donc, on met en place tout un dispositif policier qui quadrille fortement le territoire et qui vise à 2 choses. Qui vise, un, à paralyser en partie les capacités de mobilisation militantes et 2, à savoir exactement qui on est en fait, pour ensuite enchaîner sur une phase de judiciarisation. Parce que si judiciarisation, c'est-à-dire nous amener en justice, ensuite. Donc pour ça, il faut savoir exactement qui sont les gens qui agissent sur place, qui mènent les actions, qui fait quoi, qui est relié à qui. Donc cette phase-là, elle a été très intense pendant plusieurs mois, près de 1 an et demi, avec surveillance constante des domiciles, des véhicules de police garés devant, qui filment ostensiblement les gens, les allées et venues, et arrestation systématique des opposants qui se déplacent entre 2 villages, qui prennent la voiture. Et ça finit souvent au poste de police pour savoir qui sont les gens. Et dans une partie des cas, ça amène même au tribunal s'il y a eu des oppositions au contrôle de police. À côté de ça, il y a tous les moyens d'enquête. Il y a pas mal d'actions qui sont menées sur le terrain contre les installations nucléaires. Et donc, ces actions qui sont menées, elles ouvrent à chaque fois des nouvelles enquêtes policières. Et dans le cadre de ces enquêtes policières, on a une mise systématique sous écoute de la lutte, de l'ensemble de toutes nos lignes téléphoniques de la lutte, sous écoute téléphonique, qui permet de savoir exactement ce qu'on dit, comment on fonctionne, etc. On a le déploiement de moyens exceptionnels aussi de surveillance. Donc, par exemple, on a utilisé des antennes spéciales, les IMSI catchers, qui ont permis de capter plus spécifiquement le numéro de téléphone, la demande systématique aux opérateurs téléphoniques de l'ensemble de nos numéros, de tous les numéros de tous les gens qui se mobilisent sur la lutte, l'implantation de balises GPS sous les voitures, etc. Donc là, je décris un peu le dispositif énorme qui a été mis en place à notre niveau pour nous surveiller, en fait, pour nous identifier, nous surveiller et comprendre nos fonctionnements. Et seulement à ce moment-là, une fois qu'on a bien compris nos fonctionnements de la lutte, il y a la phase de judiciarisation. Et la phase de judiciarisation, elle intervient de 2 manières. Il y a la judiciarisation, ce que j'appellerais un peu du quotidien, c'est-à-dire les gens sont arrêtés sur un contrôle, ils ont un couteau dans la voiture, ils répondent aux policiers, hop, ils vont au tribunal, direct derrière. Et donc, comme ça, durant 6 mois, entre 2010, dans les 6 premiers mois de l'année 2018, on a eu près de 60 personnes passage en procès en l'espace de 6 mois, en fait. Ce qui a abouti à une vingtaine d'interdictions de territoire en quelques semaines. Donc des gens qui n'ont plus le droit de lutter à cet endroit-là, qui sont obligés de quitter le territoire, qui ne pourront pas revenir avant 2 ans, souvent. Et on a beaucoup de peines d'emprisonnement avec sursis qui dissuadent aussi les gens d'agir et de se mobiliser. Donc on a et un certain nombre de peines de prison ferme aussi, des gens qui sont emprisonnés. Donc 18 mois de prison ferme en cumulé, on a près de 5-6 personnes qui ont été emprisonnées en 6 mois en fait. Donc, ce que ça produit comme effet, c'est que progressivement, ça contribue à paralyser la lutte et les moyens d'action, en fait. Donc ça, c'est un système extrêmement efficace parce que progressivement, on ne peut plus se déplacer, on a peur d'agir et on a peur de venir. Les gens ont peur de notre terrain de lutte, ils ne viennent plus sur notre terrain de lutte et nous, on le quitte ou on est de force ou par peur aussi. Euh, et à côté de ça, il y a, et c'est là où j'arrive plus à l'objet que je voulais aborder, c'est il y a l'ouverture de la grande instruction en association de malfaiteurs. Parce que s'il y a des gens qui agissent, c'est qu'il y a des gens qui leur permettent d'agir et de commettre des actions. Donc il faut identifier qui sont les gens et quelle est la structure qui permet à tous ces gens de s'organiser et d'agir en fait. Et donc on ouvre une instruction en association de malfaiteurs qui est un immense filet dans lequel on va emprisonner toute la lutte et il va falloir savoir qui fait quoi et comment fonctionne la lutte en fait. Au départ, il n'y a rien, la police ignore énormément de choses et le but à la fin de cette instruction qui va durer plusieurs années, c'est de de comprendre nos fonctionnements et à la fin d'avoir les coupables. Parce que s'il y a des personnes qui commettent des dégradations, qui commettent des actions, qui attaquent la police, ça veut dire que derrière, il y a des personnes qui leur permettent de s'organiser, qui les hébergent, qui mettent en place des moyens structurels pour accueillir toutes ces personnes-là. Et donc, du coup, ça, c'est une association de malfaiteurs. Et c'est pas forcément les gens qui ont commis les actions, c'est les gens qui permettent à d'autres de commettre des actions. L'association de malfaiteurs, c'est 5 à 10 ans d'emprisonnement comme peine, en fait. Du coup, la procédure, elle fait extrêmement peur. Elle crée quelque chose qui rend tout le monde suspect. Et ça permet à la police d'entreprendre toutes les actions qu'elle souhaite contre un ensemble de terrains de lutte. Elle peut venir n'importe quand, dans tous les lieux, faire des perquisitions partout où elle veut, arrêter qui elle veut, parce que tout le monde devient suspect, en fait. Tout le monde est potentiellement une partie de l'association de malfaiteurs. Donc ça a amené à une vingtaine de perquisitions, des dizaines de téléphones, d'ordinateurs, énormément de saisies d'affaires personnelles en l'espace de quelques mois, en fait. Et pour aboutir à 10 personnes qui sont mises en examen, donc des personnes qui sont poursuivies pendant plusieurs années, avec 2,5 années de contrôle judiciaire. Donc interdiction de se voir, interdiction de se réunir. On ne peut pas rentrer en contact. Si on rentre en contact, on part en prison immédiatement pendant 6 mois, en fait. Euh, Tout ça, ce que ça, et au fur et à mesure, les policiers, en saisissant des objets, en arrêtant des gens, en auditionnant des gens, ils construisent une version policière, en fait, au fur et à mesure du temps. Et c'est là que le dossier commence à exister. La version policière commence à faire exister l'association de malfaiteurs en utilisant nos relations entre nous, en utilisant tout ce qu'elle trouve et en ne retirant de ça que le principe d'organisation collective en vue de faire des actions. Mais à côté de ça, un terrain de lutte, c'est aussi l'organisation pour vivre, penser d'autres modes d'existence, etc. Mais la version policière, elle ne retient qu'une organisation criminelle, elle cherche une organisation criminelle et donc toute son enquête va tendre à faire émerger une organisation criminelle. Donc, ce qui produit 21 000 pages de dossier à la fin pour notre affaire. Les effets, si je décris un peu les effets, c'est immédiatement, ça produit la peur, la suspension de toutes les communications, des traumas assez importants, les violences policières, les vexations judiciaires, tout ça, ça paralyse complètement la lutte. On a progressivement une paralysie des fonctionnements. Les outils sont détruits, les outils collectifs, puisque les gens ne peuvent plus se réunir, ont peur de se réunir, ont peur d'agir. Donc, progressivement, on perd les lieux et les outils collectifs. À côté de ça, il y a des lieux qui sont expulsés aussi, qui sont les lieux d'occupation. Donc, voilà. Euh, Maintenant que j'ai un peu posé le contexte, je voulais venir sur l'organisation collective que nous, on a utilisée face à ça, en fait. Pour nous, ce qui a été essentiel, c'était de maintenir la présence. Il fallait maintenir la présence, faire une programmation, même si tant bien que mal, ce que disait Daniel, de garder le sourire et le rire, c'est la vie collective, c'est ça qui permet de continuer à maintenir la lutte, donc de continuer à occuper les lieux et à y faire des choses. Même si on fait moins de choses, même si on peut faire beaucoup moins de choses, c'est de continuer à maintenir ça. Ensuite, on a dû décentraliser le soutien, puisqu'on n'a plus les moyens, nous, physiques, mentaux, de mobiliser forcément. Nous-mêmes, on est pris dans des procédures très longues, compliquées, on est tous en procès. Donc, du coup, on a décentralisé le soutien. On a appelé à ce que des comités se constituent partout et nous soutiennent d'ailleurs. Des comités qui, d'ailleurs, ont organisé des événements qui ont permis de ramener de l'argent et de financer nos procès, ça a généré énormément de frais de procès en quelques années. À côté de ça, il a fallu aussi préparer les gens à d'éventuels futurs procès. Donc, on a beaucoup fait de formation juridique, prévenu les gens sur qu'est-ce qu'était la procédure qu'ils avaient en face d'eux, pour qu'ils soient prêts aussi, une fois que ça leur tombe dessus, à y résister mieux, en fait. Donc ça a été un gros travail aussi qui a apporté ses fruits, puisque dans la plupart des procédures, les gens ne parlent pas durant les auditions, ce qui est déterminant aussi pour ne pas fabriquer la version policière, puisque si les policiers si on ne leur dit rien, ils n'ont rien à utiliser contre nous. C'est un peu le classique de la défense. Ensuite, on a utilisé beaucoup ce que décrivaient aussi Daniel et Nancy, mobiliser autour des procès, ça a été déterminant. Faire des rassemblements devant les tribunaux, faire des rassemblements dans les tribunaux, ce qui nous a valu d'être évacués des tribunaux à des moments, mais ça a montré l'illégitimité, ça a créé une illégitimité de nos procès en fait. Parce que ce qu'on subissait semblait injuste envers les gens et particulièrement dur par rapport à ce qu'on nous on agissait au quotidien, enfin ce qu'on faisait comme action au quotidien. Donc ça a été déterminant aussi. Et après, on a fait venir des observateurs de la Fédération internationale des droits de l'homme dans les tribunaux aussi pour constater qu'on était maltraité, que les conditions de justice n'étaient pas équitables et pour dénoncer le processus judiciaire en fait. Et à côté de ça, il y a aussi toute la nécessité de s'organiser pour rompre l'isolement, puisque la justice crée de l'isolement, en fait. On n'a pas le droit de se parler, on a peur, ça crée de l'isolement. Il fallait prendre soin, créer tous les outils du soin, créer des dispositifs qui font que entre deux personnes qui n'ont pas le droit de se parler ou de se voir, il faut qu'il y ait des personnes intermédiaires qui fassent l'aller-retour et leur permettent de fonctionner quand même ensemble et d'être en contact quand même, en fait. Donc il y a tout ça qui est mis en place, tout un tissu de résistance pour contourner les processus qui visent à nous isoler en fait. Et ensuite, il y a pour moi aussi un truc déterminant, c'est apprendre, c'est déconcentrer vraiment l'organisation de la lutte, donc faire des cercles concentriques de soutien autour de l'espace de lutte. Donc de ne plus avoir tout concentré au même endroit, mais de repousser des choses plus loin, d'avoir des nouveaux endroits où les gens puissent se reposer, d'avoir d'autres modes d'organisation décentralisés en fait. Si je passe sur la partie défense au tribunal, nous, on avait on a fonctionné sur trois choses principales. C'est égaliser la défense entre les inculpés parce qu'on n'est pas tous égaux face à la justice. Donc, il faut absolument trouver un moyen qu'on soit égaux face à la justice. Donc, on a demandé à nos avocats de fabriquer une défense qui ne nous distinguait pas, qui faisait une défense de la lutte dans sa globalité, et nous n'étions que des parties de la lutte, mais ce n'est pas des individus qui étaient face au tribunal. D'habitude, on défend individu par individu ou on s'attarde sur les individus. Nous, on a demandé que nos individualités ne soient pas abordées, que nos casiers judiciaires ne soient pas évoqués et qu'on s'attache vraiment à les faits sur lesquels on est poursuivi, en fait. Donc ça a été un des points importants. Et nous, on s'est tous tués au tribunal. On ne s'est pas défendu pour qu'on soit égaux entre nous, en fait, parce que sinon, ça aurait trop mis en évidence l'inégalité entre nous. Ensuite, on a construit aussi un procès, il y a construire le procès du procès, puisque la forme judiciaire nous isole, nous met dans des situations asymétriques, en fait. Donc, on a évidemment la médiatisation, dénoncer avec des tribunes dans les journaux entre d'organisations qui dénoncent ce qui nous arrive, la criminalisation, des personnalités qui font des tribunes dans les journaux aussi pour dénoncer ce qui nous arrive. Et on a mobilisé devant et autour des procès. Donc ça, c'est vraiment faire le procès du procès et délégitimer le tribunal, en fait. Et ensuite, déconstruire et détruire le récit policier judiciaire. Donc ça, c'est un point important aussi de notre défense, c'est-à-dire qu'on a fait des plaidoiries thématique par thématique, des thématiques politiques et des thématiques. On a déconstruit complètement le dossier et on l'a détruit morceau par morceau avec 8 avocats. Et ces 8 avocats ont attaqué chacun une partie du dossier différent, en fait. Donc on détruit progressivement tous les éléments du dossier. Et on a produit des témoins de notre côté, des témoins pour dire pourquoi on lutte, des témoins pour dire pourquoi cette affaire, pourquoi la construction judiciaire de l'association de malfaiteurs est politique, et les témoins adverses. C'est-à-dire on a fait produire le juge pour que le juge s'explique devant nos avocats de pourquoi il avait construit l'affaire judiciaire comme ça. Et donc le juge s'est complètement décomposé devant le tribunal à cette occasion. Donc voilà un peu. Et pour finir, parce que je pense que j'ai déjà atteint la limite du temps, donc maintenant, aujourd'hui, on en est on a eu des relax progressifs sur toutes nos charges. On a 4 personnes qui ont été relaxées sur les 7. Et on en est à la 3e audience où aujourd'hui, on n'est plus que poursuivi. L'association de malfaiteurs a été entièrement détruite en justice. Donc aujourd'hui, on n'est plus que poursuivi pour avoir organisé une manifestation non autorisée. et avoir participé à une manifestation non autorisée. Et du coup, l'enjeu aujourd'hui pour nous, c'est de finir en attaquant le maintien de l'ordre et la construction des manifestations aujourd'hui. Donc, c'est la liberté de manifester qu'on compte défendre dans les prochaines audiences. Voilà. C'était un peu rapide. Je ne sais pas si c'était complet, mais voilà. J'ai essayé de balayer un peu tout ça.
Thanks so much as well for sharing this, since it's a very also a personal story for you. And I want to also acknowledge how we went from a bit more like theoretical approaches or strategies to very concrete things. And I just want to acknowledge and recognize that a lot of these cases and repression, they all touch specific concrete people, and that we have to learn how to handle these things collectively and to stay in solidarity even when we are not currently affected by any legal charges. Thanks again to all of our panelists. I will now ask Carl to turn off the recording so we can have a short